Lots of the petitioner was given contract for work for cleaning and Lordship supplying electricity and various other jobs, Lordship, in all hospitals of district RI, Lordship. In terms of the agreement, Lordship, the work is found to be satisfactory. It was to be, their contract was to be extended, Lordship. But Lordship, by Annexure 6, it was not allowed without assigning any reason, Lordship. Lordship, on first occasion, Lordship directed the respondent number 2 and 3 to file counter affidavit. On last occasion, Lordship asked the civil surgeon to certify the certificates of satisfactory work issued by various.
Where is the agreement?
Lordship, agreement, Lordship, kindly turn to page 38.
Page 38.
38, Lordship.
Page 32.
38, Lordship. The last agreement, copy of the last agreement, Lordship.
Not last agreement, first one. Where is the first agreement?
First agreement was in 1915, Lordship. Then thereafter in 1915-16. 16, Lordship.
2016.
2016, I'm sorry, Lordship. 2016, then when the term ended.
2016 to 2019.
Yes, yes. And now again that was extended and another agreement
2019
to 22.
22.
Yes.
Once again you are indebted.
Yes.
Where is that?
Lordship, at page 38, Lordship, kindly turn to Anubandh Avadhi Ka Vistarikaran. Page 38, Lordship. They don't give any reason, Lordship, by any.
What is the reason for
No reason, Lordship.
discontinuing?
No reason.
We are asking.
Yes.
My Lord, in terms of the cabinet decision issued by the government of Bihar, my Lord, a new resolution has been issued, my Lord, and also new scenario has been developed in the state, my Lord.
That the government has changed.
My Lord, it has been mentioned that the cleanliness work of hospital and providing diet to pregnant women would be done by the Jivika, my Lord. And a new financial guideline has been issued, my Lord. Your Lordship may kindly see Annexure R3/C of my counter affidavit.
You have brought on record these documents, the policy document that Jivika would be given the work of cleaning and other.
Yeah, it is in the counter affidavit filed by the collector, Lordship. It has been brought, the decision. But Lordship, it is a very limited application. Jivika has been given only 2 work, Lordship. Cleaning of clothes and some cleaning. And only 2 hospitals, not all the hospitals. So that doesn't bar. And Lordship, that will not operate retrospectively, doing away with the terms of my agreement, Lordship. If they again enter into agreement with me, they can now opt out that provision in Lordship.
Lordship may kindly see Annexure R3/C of my counter affidavit, my Lord, filed by respondent number 3, my Lord, at page number 23, my Lord. Annexure R3/C at page number 23, my Lord. New financial guideline has been issued, my Lord, in financial year
Counter affidavit by R2.
2022. Annexure R3/C at page number 23, my Lord. At page number 20. I am reading in the bottom portion.
represents the cleaning of the hospital buildings. Hospitals. Jivika.
The resolution. The vote of cabinet.
Lordship, the job to be given to Ajivka is very restricted. First, Lordship, this is which is clear from this Annex R3, only 2 hospitals. Whereas I am being,
Come to page 14. Cabinet decision.
Lordship,
Item number 12.
Lordship, सभी सदर जिला अस्पतालों एवं अनुमंडल अस्पतालों में, whereas I am looking after the primary health center, referral hospitals and all, so only 2, and Lordship, only 2 work. मरीजों के लिए वस्तुओं की आपूर्ति एवं भवनों की साफ सफाई.
Enough, sir. We will ask them to issue fresh tender. You also participate.
Lordship, fresh tender has been issued.
Renewed for on.
Lordship, fresh tender has been issued. We have also participated, as your Lordship directed on the first date itself. But Lordship, my respectful,
Till completion of fresh notification tender, you continue to.
no, Lordship, my respectful submission, Lordship, will kindly consider, in view of the agreement, Lordship, in view of the terms of agreement, that it will be further given if no specific or whatsoever any allegation is there against me regarding dereliction of duty or incompetence, Lordship.
For
It would,
ever you can't have the benefit of that clause.
Lordship, the state is free to enter into an agreement and omit that agreement for.
Go and approach the state government.
No, Lordship,
We will not come in that.
Lordship, the state government is bound by this terms of agreement, Lordship.
We say that-
And any further,
We say that they are not bound because it is already once renewed. It is already once renewed.
but Lordship, there are subsequent agreement is a independent agreement.
Yes, sir. We will.
It has no connection with the first agreement, Lordship.
All right. We will make an observation. Who has entered into the agreement has not noticed that the policy decision.
Lordship, even Lordship, a act passed by the legislature, Lordship, has prospective, Lordship, operation, not respective, Lordship, the right already accrued to me by dint of that clause, Lordship, cannot be taken away by a cabinet decision, Lordship, which will operate prospectively. And Lordship will kindly see the final letter issued at page 17, Lordship.
Sir, cabinet decision is there, sir. We are.
Lordship, cabinet decision will not override the terms of agreement, Lordship, with great respect. It's by submission, Lordship.
Then go and file a suit.
Lordship, in suit,
You go and file suit. We will.
Lordship, in suit, government cabinet decision cannot be challenged, Lordship.
No. Insofar as the execution of this agreement.
Lordship,
Execution of this.
Lordship, established law, in terms of established law, Whirlpool Corporation and other cases, Lordship, if there are, Lordship, arbitrariness with regard to in terminating the order,
We
Lordship.
find that the co-arbitrariness.
Lordship, arbitrariness is writ large in the Annex 6 itself.
We will consider that.
Lordship can do anything, Lordship. Parliament and court under Article 226 can declare night and day, Lordship. But Lordship,
At the same time, you have a remedy before Delhi.
Lordship, there is no arbitration agreement even in this case. I have only remedy before the civil court. And civil court will not, Lordship, declare the decision of cabinet ultra-virus, Lordship.
You
Civil court.
can question the cabinet decision. You can ask for execution of this condition.
Lordship, I am not asking for enforcement of that clause. I am only pointing out, Lordship, to the disposal of my application in terms of Annex 6, which having accepted that my work was satisfactory, even then it goes to violate that provision of law, Lordship, which is protected under Article 226, Lordship.
Yes, sir. Anything else?
Lordship, any subsequent decision cannot take away my right.
Yes, sir.
It is a contractual right, Lordship.
Therefore, you go and invoke.
Lordship, alternative remedy is not efficacious. Alternative remedy is not efficacious, Lordship. In suit, it will take, in my lifetime, it will not be decided. If there is no alternative remedy, Lordship, and Lordship, there is a case of arbitrariness, there is a case of violation of Article 14. I am well protected under Article 14, Lordship.
Yes, sir.
It is to be
For not at the cost of 2 persons.
Lordship, the cabinet has only bifurcated the works, Lordship, and certain hospital, that hospital can be,
Sir,
not be.
you also participate in the fresh tender.
I have participated, Lordship, as your Lordships observed the first day, but Lordship, my right by participating or by issuing a new tender, my earlier right, Lordship, accrued under the agreement cannot be taken away.
Yes, sir, we will decide that.
But such types of conditions in the agreement, it violates others' rights also. It violates.
Lordship, kindly countenance one situation. In terms of service rule, everyone appointed in the government service, Lordship, will retire at the age of 60, 58, 60, 62. Lordship, if the government thinks that since there is a lack of employment, now the terms of the term of tenure, Lordship, should be reduced to 10 years each. Can it, Lordship, my question surfaces, can this be implemented? Service condition can be changed. Same way, Lordship, terms of contract cannot be changed. Lordship, contract are the basic foundation of any republic. Contract doesn't have less. Lordship, that is very easy to say, but Lordship, no. It is the alternative remedy is not efficacious. Lordship will relegate me to alternative remedy only. Lordship, it's a rule of discretion, not a rule of law, that Lordship will relegate me to a civil court. Lordship, see, Lordship will not permit the state to violate the agreement, Lordship, contract.
That's what we are saying, that if every agreement is being violated, you have got a forum where you can agitate this.
Lordship, I have forum, definitely civil court.
Not something that it is.
Academically speaking, Lordship, civil courts are the forum. But Lordship, practically speaking, in this case, civil court is not a forum. Remedy is not efficacious and effective. And Lordship, relegation, doctrine of relegation to the civil court, Lordship, is a rule of discretion. It's not rule of law. Lordship, in so many cases where arbitrariness has been found, so explicit on the order, Lordship, so explicit in the conduct of the state, Lordship, Lordship will definitely interfere. Article 14, Lordship, comes in the way of government, Lordship. Completely arbitrary exercise of power. Lordship, the order doesn't say that we are going to change the policy, and even policy doesn't say that no society would be given such work. There is no such policy, Lordship. Only a new instrumentality, a new
contract to be perpetuated for infinity.
Lordship, Lordship, if now they enter into contract, they may omit that, Lordship, in view of they will not have this term in the contract, that any further extension. But since once the state, Lordship, have agreed in the contract, the state should be bound down, Lordship, by a Lordship's order. This is a very simple thing, Lordship, whether violating in this way attracts Article 14 or not. $107 is 220, 2,307. Yeah.
Sir?
Lordship, the Supreme Court, Lordship, has laid down three Lordship principles while dealing with such governmental contracts, Lordship. First one, where the writ petition seeks enforcement of any of the fundamental right. Lordship, I am seeking enforcement of Article 14, safeguard from arbitrariness, where there is failure of principles of natural justice. Yes, Lordship, in this case, natural justice also is violated. Where the order or
How it is violated?
Lordship, natural justice.
Principle of natural justice is violated?
Lordship, natural justice demands that apart from odi alteram partem, that the authority will proceed in accordance with law.
Correct. In what manner they have violated Article 14?
Lordship, they have violated their own undertaking,
That is a different.
agreement. And Lordship, and third one, Lordship, where the order or proceeding are wholly without jurisdiction.
That is not available
So,
to.
Lordship, there is no jurisdiction to, Lordship, not to extend my, unless there is an allegation of.
When there is no jurisdiction, where is the question of extension? When there is no jurisdiction to extend, extension, at the same time.
Power is not open-ended, Lordship. It's bound down by the condition that if there are complaints,
They have no jurisdiction.
if there are complaints, only in that circumstances, my extension will not be done. There is no other reason, in Lordship.
All right, we'll consider that. Yes, take up. The instant petitioner has prayed for the following relief. The petitioner was a contractor in maintaining the hospitals. To that effect, an agreement was entered for a period of 3 years during the period from 2016 to 2019 with a clause that
19 to 22.
contract would be reviewed
19 to
for a
22.
period of 3 years if the work of the petitioner is satisfied. Accordingly, it was renewed for further period of 3 years during the intervening period from 2019 to 2022. At the time of renewal of contract, identical condition was imposed to the extent that in the event of petitioner's work is satisfactory, work contract would be renewal by 3 more years. Full stop. Next part. In the light of condition imposed in the second agreement, that in the event of petitioner work is satisfactory, is entitled to further 3 years period of contract is sought to be is a subject matter of the present petition. Full stop. Learned counsel for the petitioner submitted that he has a vested right to continue for 3 more years in the light of later agreement, conditions in a later agreement. So, in not adhering to the condition imposed in the later agreement, there is a violation of Article 14. And other principle laid down by the apex court in the case of
Harbanslal Sahni versus Indian Oil Corporation, 2003, Volume 2, SCC 107.
so and so. Full stop. Per contra, learned counsel for the respondent resisted the aforesaid contentions and submitted that Cabinet has taken a decision to resort at another policy cabinet decision is wide dated
27/1/2023 million.
27
27/1/2023.
27 1 2000.
23 million.
Item number 12. In the light of cabinet decision, the state has taken a decision not to renew the contract of the petitioner.
Pardon me, Lordship. The state has not taken this ground, Lordship. Collector has not taken this ground that since Ajivika have been taken as a accepted
That
as
is what his submission.
Lordship, the Annexure 6 declining extension doesn't speak about this.
All right. Has taken a decision. Therefore, indefinitely not entitled to continue the contract while violating the Article 14 for other similarly situated contractors to participate in the process of fresh tender. Full stop. It is also submitted that writ petition is not maintainable insofar as implementation of various conditions of the agreement under the Contract Act, agreement entered under the Contract Act. Full stop. Heard the land councils for the respective parties. Undisputed facts are that the petitioner is a contractor and he has been awarded work order for the period from 2016 to 2019 for a period of 3 years insofar as the execution and maintenance of certain hospitals. Full stop. In terms of agreement, in terms of one of the condition in the agreement,
Lordship, further
for 3 years,
from 2019.
before that his work was satisfactory. Full stop. By executing second agreement, identical conditions were imposed. Full stop. Identical condition was not given effect to. On the other hand, concerned respondent has taken a decision not to renew the contract. Hence, petitioner is aggrieved by the decision. Next paragraph. Before adverting to the contentions of the respective parties, it is necessary to take note of preliminary issue that whether writ petition is maintainable or not insofar as execution of terms and conditions stated in the agreement. So, the petitioner has a remedy before the appropriate forum in terms of the following clause, page 38, extract karo. In the light of the aforesaid clause, the petitioner should have approached this court with the clean hands. On the other hand, in the writ petition, in the pleadings, the petitioner has pleaded in para 15 as under subpara that the petitioner has no other alternative remedy equally efficacious other than to file the instant writ application. Full stop. On the other hand, the petitioner should have been fair enough to apprise this court that he had a remedy in terms of the aforesaid clause mentioned supra. Therefore, petition is liable to be dismissed on the ground that the petitioner has not approached this court with the clean hands. Sir, be that as it may, next paragraph, be that as it may, it is necessary to take note of whether is there any violation of Article 14 insofar as not giving effect to the one of the condition in the second agreement to the extent that petitioner is entitled to renewal of his contract for further period of 3 years. At this stage, it is to be noted that petitioner is executing the work for the last 6 years. With reference to initial agreement for a period of 3 years. Indefinitely, the petitioner is not entitled to continue to hold the work order merely because one of the signatories officials of the state government. So before such a renewal arrangement is made by the official respondent, he or she must think of Article 14 to the extent that they are depriving opportunity of participating in the process of execution of public work like the present one. Full stop. Next, the cited decision do not assist the petitioner for the reasons that it is not a case that impugn action is by an incompetent authority or impugn action is in violation of Article 14. To stop. In the light of these facts and circumstances, the petition, that apart, it is noticed that state government has taken a policy decision in the light of a cabinet decision dated 27/1/2023. So, cabinet decision at item number 12 reads as under. Next one. In the light of these facts and circumstances, the petitioners have not made out a case so as to interfere with the action. Apart from the petition is and dismissed, reserving liberty to the petitioner to invoke a remedy before the appropriate forum in terms of what is this? In terms of condition, namely settlement of disputed within bracket cited supra.
That only says the jurisdiction of the court. That doesn't provide any alternative remedy.
All right.
Your Lordship's observation that I have suppressed the fact, Your Lordship, is wrong, Your Lordship.
All right, you take up this matter to Delhi. In terms of para 15, we are of the view that you are suppressed.